Well, good afternoon, everybody, and thank you for joining us here at the Society for the Rule of Law for our annual Supreme Court term review. It was a historic year at the court, and we have a lot to talk about today. Before I dive into the substance, I just wanted to say a bit about who we are and what we have in store for us today. The Society is a group of mostly lawyers, mostly on the conservative end of the spectrum, who prioritize the defense of the rule of law and the Constitution over passing partisan interests. If that mission sounds appealing to you, we'd love to have you as a member. Society is a membership organization. Our members make possible all the programming we do, both in-person events and online events like today. So please consider joining. There'll be a link to membership in the chat, and you can click there. We have membership at several levels for lawyers, non-lawyers, academics, students, and more. We would welcome your support. And speaking of the programming, we have two events coming up this summer I'd like to note for you before we get going. One is our next live in-person event. That's here in Washington, D.C. on the evening of July 25th. It's at 6 p.m. The event is a book talk with conservative scholar Yuval Levin from the American Enterprise Institute on his new book, American Covenant, How the Constitution Unified Our Nation and Could Again. Again, that's July 25th at 6. There'll be a link to register in the chat. Our next online event is at the end of the month, another webinar. It's on Wednesday, July 31st at noon on academic freedom and the First Amendment on campus. That'll be with our guest, a charter member of ours, Keith Whittington, who had been a professor at Princeton and is beginning a new position at Yale Law School this fall. We're delighted to have him and hope you can join us for that as well. Now to the main event for today's programming. This is on the record. We are recording. You can follow up on this on our YouTube channel after. But while we're here, we really appreciate the live viewership and invite your questions. I'm going to try to leave at least 10 minutes at the end of the event for questions. Please drop any questions you have in the chat, and I will pick ones that I could put to our excellent panelists. Which brings me to those panelists. Today, we're joined by Stuart Gerson, who is the board treasurer of the Society for the Rule of Law and the former acting Attorney General of the United States of America. We also have with us Professor Jonathan Adler, who's a professor of law and the director of the Center for Business Law and Regulation at Case Western University School of Law. Two different and really insightful perspectives we will have on the court's term. So with that, I will bring us to the substance. And before I ask each of our panelists to give us an overview of kind of the fullness of the court's term, I'd like to start with a brief discussion about Trump versus the United States. This is a case that dealt with former President Trump's claim of absolute immunity from criminal prosecution. It's a case that I think was very important to a lot of the members of this society. Many of us joined briefs in the matter and had strong opinions. We published over the weekend a reaction on our website from another of our charter members, Richard Bernstein, who argued in the headline that Trump versus U.S. is the new Roe versus Wade. I think to cue this up and ask these two gentlemen for their takes, there have been certainly a lot of criticisms of the case across the spectrum. I think criticisms that I've seen from the right maybe fall into three or so categories. One is the claim that this case just was too broad, that the court should have dealt with the narrow facts before it, the specifics of the Trump case, and not tried to establish a rule for the ages, as Justice Gorsuch had mentioned at oral argument. Other arguments focus on the methodology, suggesting this was not a truly originalist case. It was poorly grounded in history and text, and it was really judicial policymaking, which is largely what Rich argues in that piece that's on our website. And the third is that the test that was announced was just a bad test. That it's either it was poorly delineated or it misunderstood the real dangers or threats to the separation of powers that we'll practically have going forward. So if it was a constitutionalist decision, perhaps the consequence. If it was a consequential decision, perhaps the consequences were misunderstood by the justices. So with that, Tia, those are some of the negative things I've heard. I'd love to hear from both of you whether you agree with the attacks on the decision or whether you'd like to make a case for its strengths. So I'll start with you, Professor Adler, on this one.
Well, thanks. It's a pleasure to be here, and great to be part of this program. And it's exciting to see all of the programming the society is doing. I think when a bunch of us got together to form what was then called Checks and Balances, we had no idea what would bring, and it's great to see how much the society and its members are doing. So I'm of two minds about this decision. On the one hand, I share the concern that this decision embodies a view of executive power and of presidential immunity that is atextual, that is hard to ground in kind of an original public meaning of the text of the Constitution. But I didn't expect that in the opinion, and I didn't expect that for a couple of reasons. And this is why kind of the second half of being of two minds. One is no party asked the court to evaluate it that way. And two, there's a lot of precedent pointing in the other direction. The Youngstown Steel framework that Justice Robert Jackson articulated plays a big role in this opinion, as does the case of Nixon versus Fitzgerald, which, like Roe versus Wade, is a burger court decision that has all of the hallmarks of the burger court. And I think given those precedents, and I think given the nature of the case, the magnitude of the case, the speed with which it moved through the courts, we shouldn't have expected something different than that. And let me just quickly unpack why I say that, and in the process, kind of just loosely summarize the case for those that haven't really focused on this. So what the court says is that in thinking about whether or not a president can be prosecuted, and we're really talking a former president can be prosecuted, because the court takes as a given that the Justice Department, under the control of the president, is not going to prosecute a sitting president. That you have some things that a president does that are kind of the core aspects of executive authority. And those things are things that Congress can't regulate, can't control. And so it follows that Congress can't criminalize them. And the example that probably comes most to mind, or that is most grounded in court precedent, would probably be the pardon power. Perhaps if we focus on precedent, not so much on text, the removal power might be like that as well. At the other extreme, there are things presidents do that, while they are president, are not official at all. And those things are not immune to prosecution at all. And I think most of us believe that the vast majority of the things that are in the indictment of Donald Trump fall into that category. And I don't think the court says anything that prevents that conclusion. I would have perhaps liked the court to show its hand more and to confirm that. It's unfortunate it didn't, but I think read closely, I think the opinion does very little to disturb the view that I think most of us have, that the vast majority that's in the indictment was unofficial conduct. In the middle, there are things that are official acts, things that the president does pursuant to the president's constitutional authority that are presumptively immune, but that presumption can be overcome if the prosecution can show that prosecuting those acts will not interfere with the president's ability to discharge the president's responsibilities. And the court identified this category, didn't give us as much detail on it as I would have liked. And that's the sort of thing that lower courts are going to have to wrestle through. Really quickly, because I don't want to go on too long, why do I think this is what we should have expected? Well, this looks a lot like Justice Jackson's framework in his Youngstown Steel opinion that everyone learns in their common law class, introductory common law class in law school. It also, I think, maps in many respects onto Nixon versus Fitzgerald, which, for purposes of civil liability, said that a president is immune for all official acts. And I think what the court says here, well, for criminal prosecution, where the stakes or where the public interest is higher, there's presumptive immunity for that full range, but the absolute immunity that extends to all civil liability only extends to criminal liability for things that are at that core. So I think given those precedents, this is what we would have expected. That said, I prefer Justice Barrett's concurrence than the Chief Justice's majority. I think the court could have said more to provide guidance to lower courts about how to apply this. But what I think will happen, assuming the case is able to proceed, is that most of what's in the indictment will be found to not be immune. I think the lower court will apply the framework suggested by the DC Circuit's Blassingame opinion, which is cited favorably by the chief and is not in any way disturbed, but that will take time. So for those who were hoping for a full prosecution and a trial before the election, that even if that was a reasonable possibility, this opinion certainly makes clear that that's not going to happen. And I've probably gone on too long, so I'll stop there.
That was excellent. Stuart, what are your thoughts on?
Well, Professor Adler and I often agree and have a long historical record of having been on the same side of things. So it should be unsurprising that I don't disagree with a single thing that he said. But I want to look at the case in slightly different terms. And let me make full disclosure at the outset. I was an amicus in the case, suggesting a somewhat different result than what obtained from the court. And I'll talk about that because I think the position that I and my friends took in our brief was the right one, and that the court should have and could have decided the case. But I'll explain why I think it didn't want to do that under any circumstance. The other part of my full disclosure is that many years ago in 1974, I was among the counsel for the United States in a case called United States against Daniel Brewster. Brewster was a sitting senator, and I got to argue. I didn't argue in the Supreme Court, but then I argued on the remand against Edward Bennett Williams. It was a great treat, and the law was well staked out in that case. That a substantial majority of the court held that the speech or debate clause, which is analogous to what was being argued here in executive terms, that the speech or debate clause did not protect acts that couldn't be official duties, and accepting bribes was one of those things that a prosecution could rest on, irrespective of whatever protection obtained. And having said that, I note that there is a core that was represented in our amicus brief that simply said to the court, you can decide this case on narrow grounds. For example, with the executive vesting clause of the Constitution in mind, recognized that the president of the United States and certainly an ex-president has no role in the certification of electors. And so a conspiracy to overturn the election by putting forth a phony slate or a slate of phony electors is something that clearly is unprotected. And if the court had wanted to do so, there's no additional facts that need to be found with respect to that or most of the other things that Professor Adler pointed out correctly are not official acts. So I was disappointed that the court didn't decide the case. Why did the court not decide the case? Well, my starting point for thinking about that goes back a couple of weeks to the Trump and Anderson case, the Section 3, 14th Amendment Section 3 case, which was unanimous. And I think, and Jonathan's going to talk about this a little bit later, what the Chief Justice's role is in trying to administer the court that has some serious divisions. But I think as a whole, this court doesn't want a repeat of Bush against Gore and doesn't want to be seen to decide the election. I think that explains a lot about the Section 3 case where in Anderson, where the argument was, and you can tell in the oral argument, why should we rule with respect to one state something that's going to decide the case for all the states and is going to determine the election. I think the same thing is true with respect to Trump against the United States. It does mimic in a lot of ways what the history was under President Truman with regard to the steel seizure case that was that was the subject of Youngstown Sheet and Tube against Sawyer. I think that's where the court is. So, my bottom line is I'm disappointed. I think the court could have decided the case, that there's no need for a remand if the court took a limited view of what it needed to decide. And so it's a much broader decision than it needs to have been. That's my view of the thing. But that said, there's nothing wrong with the analysis either.
If I could jump, well, I did want to flag one thing that and Stuart may agree with me on this as well. There's one part of the opinion that I think is quite problematic, the lower courts are going to have a really hard time with, and that's this section that Justice Barrett refuses to join about bringing evidence in. And so, just for folks that haven't followed this that closely, one of the things that's in the indictment is a meeting between Trump and the Attorney General, and there's a question both about whether or not that's an official act, but also the extent to which that can be introduced. And the court says it's an official act, president meeting with the Attorney General. That's clearly official act and fairly core given the president's removal authority under existing precedent and prosecution being such a core executive function. The court then goes on to say that the content of that meeting can't be introduced as evidence, is ambiguous about whether the fact of the meeting can be introduced as evidence. And I say it's ambiguous because there's this language suggesting you can't bring this evidence in. And then Justice Barrett says, wait, that's a problem. And then there's footnote 3, which says, well, you can bring in the public record of the official act, but you can't bring in the discussion, right? So applied to this context, what was said between the president and the attorney general, you can't bring in. And there is language in Nixon versus Fitzgerald about not inquiring into motive, which this is clearly drawing on. But the evidence of the official act, the public record shows that, so you take judicial notice of this. So how do we transpose that into other contexts? The opinion's unclear. The Chief Justice is a very good writer. Why is it unclear? Is he papering over differences among the justices? I think that's a possibility. Was this just July 1st is coming, we got to get the opinion out? That's a possibility. I don't think we know, but I think that's the part of the opinion that is going to be the hardest for lower courts to figure out precisely what to do with, and one that I think has, because of its lack of clarity, has really troubling implications in the sense that it will take time to work through the rest of the court's analysis. I like to think the courts will be able to reach the proper outcome for most of it. But this question about like when you can bring evidence in and what kind of evidence and how unnecessarily muddies something. And it's very different than what the Chief Justice suggested in oral argument. If you go back and look at oral argument, he was with Justice Barrett's opinion on this question at oral argument. At least it sounded that way. And that was a wholly unnecessary part. Stuart pointed out the opinion. There are a lot of things the opinion could have done and didn't do. This is wholly unnecessary, and muddies the waters in ways that I think are very unfortunate.
Well, I certainly do agree with you, and I with my tongue half in cheek, I noted I was particularly interested in this point because I once was in that position of being able to speak with the president about these kinds of things, and without revealing any communications, the substance of any communications. It's well known that he and I discussed Operation Desert Shield and Desert Storm, I'm certain that the late President George H.W. Bush would not have intended that any of that conversation be made public. As I say, it turned out well. The operations were successful. That said, there wasn't a public controversy where people were seeking this kind of information. The nation was quite unified with respect to those activities. Success has 1,000 fathers, as the parable goes. But I certainly thought about it, and again, what the dynamic was that led to what I viewed as an unnecessary and muddled discussion of an issue, I can't say. but I certainly agree that it's problematic.
Got a couple of quick follow-ups before we move on. One, just while we're talking about Barrett's concurrence, there's some suggestion there and a broader conversation that the court shouldn't have been thinking about this, or we shouldn't think about this so much as presidential immunity as we should think about it as limits in Congress's power, right? What they can criminalize. It's not a right the president has. Does that practically matter if you were to approach this case from that direction? I can start with you, Professor Adler.
I mean, well, yes and no. When you combine it with interlocutory review, much less so, right? But I think it, whether or not it cashes out in a meaningfully different way, I think it might be less important than the way we think about what's going on. I mean, I think a lot of us intuitively don't like thinking about presidential immunity as a concept, and might even, and this would take us off course, but there's a lot of other contexts where there are judicially recognized immunities that are atextual and ahistorical that people are increasingly uncomfortable with, prosecutorial immunity, for example, and so on. So I think part of it is just, do we want to think about this as an immunity or just as a necessary consequence of the separation of powers? And I think thinking about it in the latter context focuses us on the right questions, right? Which is, what is it that's, that a president is or a former president is potentially being prosecuted for? So that, I think, is helpful. There is a secondary question about, do we need interlocutory review? And on the one hand, you're talking about a former president. Is speed all that important? Nixon versus Fitzgerald, if I recall correctly, that suit was filed in 1974. It's heard in the Supreme Court in the 1981 term. Multiple presidential administrations later. Arguably, the reason for interlocutory review is if you have to worry about confidentiality, maybe you need those sorts of things dealt with before a trial. But you add those two together, it's not clear how much it's going to cash out differently in a given case.
Well, I agree with that, but I'll also note that I think that viewing this as a matter of separation of powers more closely reflects the way that most of the court is thinking about the court and the court's role. And I think this is a separation of powers oriented court. We're going to talk about Loper Bright in a little bit. I'm going to speak particularly about what I call the decline of the administrative state. And I think all of this is a piece in the way that the court's viewing itself as a guardian or restorer of more traditional notions of separation of powers, and that there's a lot of this in Loper and in other cases, going back to West Virginia against EPA on the civil side, where the court is talking to Congress and saying, Article 1 is in first place for a reason, and energy in the executive doesn't mean lassitude in the legislature, and that you guys have a job to do. You ought to do it. And so I think that that's a subtext in all of this. Another thing to be said with regard to Justice Barrett, she is certainly surprising to me in as much as I just didn't know a whole lot about her. But it's become popular to talk about her showing a streak of independence. That's certainly true, but look at what she's showing independence as to. Separation of powers, I think, is reflective of the what I think is the growing recognition that in a highly technological age, where we're going to start seeing cases involving artificial intelligence and other efforts, other areas where government is going to attempt to regulate, that she is going to be a strong separation of powers judge, a pretty ardent textualist, and I think that she's spelling the fact that originalism has peaked as a doctrine.
Well, Stuart, I could go on the Trump case for another half hour, but we ought to move on to the rest of the term, and you've already opened that up for us. So perhaps now would be a good time to ask you to give us your meta thoughts on the term and cases you thought were most interesting, other than Trump against the U.S.
Well, I want to talk about the administrative state and places where the agencies have taken a hit, and where that is of great significance, and where perhaps the magnitude or duration of the hit is being overrated by catastrophists. Of course, the other major case besides Trump against the United States of the term was the Loper-Bright case, and the overruling of Chevron. The Chief Justice.
And so could you give just a quick plug on what Chevron is for the generalists or non-lawyers among us?
Well, it's a good question to ask, because a lot of people misunderstand what Chevron is. Chevron is a case that involves statutory authority, and what happens when you have an ambiguous statute. The case of Chevron itself ended up with a two-step analytical mode. The first of which was to determine whether or not that Congress had so specifically enough addressed the situation of authority in the statutory language, which if it did would end the inquiry. And if it didn't, what should happen? Well, in short terms, it's the doctrine was that the court would defer to the opinion of the agency to resolve whatever ambiguity there was in the statute. Over time, that purpose was transmogrified greatly, and Chevron was applied, as many critics today or of Loper and adherents of Chevron were saying, to administrative decisions within the compass of things that were clearly delegated to the agency. That's not what Chevron was about. It's not what Chevron held. It's important to note that while Chevron was a precedent in probably thousands of district court cases since its decision 40 years ago, hadn't been relied upon by the Supreme Court itself. I think the last time that the court relied overtly on Chevron was in 2016. And indeed, in more recent times, even where the court had asked the Solicitor General and others, and I'm thinking of one of the two Becerra cases that was decided this term, for their view as to the viability of Chevron, the court never even cited the case. In West Virginia against EPA, which involved the major questions doctrine, and an attempt by some to have the opinion of the EPA accepted as governing in the case with regard to some issues that had to do with emissions from factory smokestacks. Chevron appears in exactly one place in that opinion. It's in a little footnote, and it has nothing to do with the decision in the case. So the power of Chevron in the Supreme Court had been greatly diminished by the time we get to Loper. Now, I'll confess I was a bit surprised by the decision. I thought, because of a case called Kaiser against Wilkie, which had to do with the Auer doctrine, AUER, which was questions of deference to agencies in interpreting their own ambiguous regulations, an opinion written by Justice Kagan, which I thought was very pragmatic and useful. I thought that Justice Kavanaugh would join with her in Loper, and that we'd see something other than the sorts of things that were in her dissent might fashion a 5-4 majority with the chief. That didn't happen. But what's the bottom line? Okay, Chevron is overruled, is inconsistent with the Administrative Procedure Act. In a sense, Chevron really didn't have a whole lot to do with the Administrative Procedure Act. I'll explain in a second why. But the Chief Justice concludes with the idea that these kinds of jurisdictional matters, that's not what agencies are expert in anyway. Those are things within the province of courts, and it's for courts to decide them. Okay, that seems to me to be right. But what one ought to keep in mind is that, for well or ill, while we're already seeing a flood of cases looking to benefit from Loper, the court is going to tire of them quickly, because most of those, when you really get down to it, are questioning agency judgment about the application of their expertise in areas where they actually have it. And I think there, another case that Chevron had nothing to do with but could have was in the COVID mandate cases, where with regard to the narrowly drawn HHS mandate as opposed to the OSHA one, which was overturned because it was too broad and clearly had not been delegated, the subject of a clear delegation by Congress. The court said within the bounds that were clearly delegated to it, the agency knew about COVID and what to do, not the court, and upheld what had been done. So that's what's going to happen. I do say, though, that the situation has been muddied by another case. I think the world can live with Chevron, because for two reasons. First, the Chief Justice made it clear that agencies were entitled, in his word, to respect, and they'll get it with regard to technical matters. And the other thing is that the repeal of Chevron takes us back to Skidmore. Skidmore also involved a certain level of deference to the agency upon proof that the agency was acting in a reasonable manner consistent with the statute. That's a workable model, and I think most courts will be able to deal with it. The downside of Loper is that under Chevron you had one-stop shopping. The agency made its determination. Here you're going to have 94-stop shopping with all the district courts, and of course there are going to be inconsistencies. There'll be a lot of forum shopping, but there'll be plenty of inconsistencies in the way that those courts rule, and likely the way that the circuit courts rule. So there's that operative difficulty that Loper-Bright causes. But the other thing has to do with the statute of limitations under the Administrative Procedure Act and the court's decision in the Corner Post case, where the court reversed the decision below and held that an APA claim doesn't accrue for purposes of the statute of limitations until the plaintiff is injured by final agency action, not from the date of final agency action, but from the date of injury. How in the world, you impose limits on that is hard to know. By its terms, Loper is not retroactive, but what exactly is this decision in Corner Post going to do? I thought the dissent made some valid points. Jonathan can comment on that if he chooses to, but that adds a problem to the application of Loper.
All righty. Greg, when we talk about Loper, when we talk about I'll say a little bit about the term, and then I'll pivot to the administrative state stuff.
Perfect.
Just generally on the term as an initial matter, I mean, some things to keep in mind. Court only heard 61 cases, producing 59 opinions. This is a tiny docket. The court's taking very few cases, a lot of big cases, but the overall docket so much smaller than it used to be. I mean, we can remember when the court would decide over 100 cases a term. That shrinkage means it's remarkable how undivided the court is in the opinions that in the cases that remain. So the court, 45 or so percent, 45 to 50% of the cases being unanimous is quite remarkable. We know the chief wants to do that. This was a term where the Chief Justice was in the majority more than any other justice. The last several years that have been Justice Kavanaugh. I think the Chief Justice prefers it that way. You look at the big high-profile cases this term. The Chief Justice took most of those for himself, and I think wrote opinions that would command as broad a majority in controversial contexts as he could. So Trump immunity case, Loper-Bright, the Rahimi case on gun rights, the Jarkissi case, another big administrative state case. He kept all of those for himself. And I think you see in a lot of those opinions him balancing the views of different parts of the majority coalition on the court. And I think that's something to watch going forward. We already talked about how that might explain footnote 3 in the Trump immunity case, the fact that he was probably trying to hold together a single opinion that 5 justices would agree on. I think you see that in some other cases. I think you see that in the Loper-Bright opinion. I think there were some justices that wanted the bottom line of that opinion to say Chevron was overruled. Justice Gorsuch has a line in his separate concurrence. The court places something like the court places the tombstone on Chevron that no one can miss. Right? Some justices wanted that bottom line. I think you actually read the guts of the opinion, and I'll post a link in the chat to some stuff that I've written on it. It's not as broad an overruling of Chevron as one might have expected. It's not an opinion that says every time a court has to interpret a statute that an agency implements, it must do so de novo without any regard for the agency. No, it says that courts should in effect do what they were arguably doing prior to Chevron, what the court arguably thought it was doing in Chevron, which is recognize there's agency expertise, recognize the agency may have actually played a role in drafting the statute, recognize there are reliance interests, but recognize that those are things that make an agency's explanation or interpretation persuasive, not things that require or obligate the court to follow the agency. And so, this language about respecting the agency as opposed to deferring to it is really important. I think that shift was something the chief was interested in. I think the chief was also very interested in highlighting and emphasizing that the key question in all of these cases, and this is what unites this opinion with the various major questions cases, what is always the first question for the court to be thinking about is, what power did Congress give the agency?
If I might intrude for just a second, I was just thinking of that and looking at the opinion. And to me, it came down to 2 lines that the chief wrote. If you'll forgive me, I'll quote him. In short, there is no basis to conclude that statutory ambiguities are implicit delegations to agencies. Moreover, Chevron is misguided because agencies have no special competence in resolving statutory ambiguities. I mean, that to me was the kernel of the matter. Elsewhere, by implication, that says that the competency of agencies, not the court, is in resolving questions of a technical, medical, scientific nature.
Yep, very much so. And if you look at what the Chief Justice did in the student loan case in Western University's EPA, you look at what the court did in the OSHA COVID case, and you look at what the chief talked about in oral argument in some of those cases, there's very much this concern that agencies should not be allowed to decide what they want to do and then go rummaging through the US code after the fact to find legal authority for it. Agencies should not be, as I've put it, pouring new wine out of old bottles. Agencies should be faithfully discharging the things that Congress has told them to do. Agencies should be, with whatever discretion Congress gave them, implementing the statutes that Congress enacted, but not engaging in this practice, which we've seen this administration do, we saw the Trump administration do, we saw the Obama administration do, we saw the Bush administration do, which is try and massage or wrestle with the text of statutes passed 10, 20, 30 years ago to do what the current administration wants. And this opinion makes that much harder to do. It emphasizes that under Skidmore, contemporaneous interpretations of a statute by the agency are worth a lot more than things they've come up with later. We see that seam in the major questions doctrine cases as well. And one of the things, this is interesting, and I'll just use the environmental law context where I spend a lot of time as an example of this. Back in the late 20th century, every major environmental statute was reauthorized and revised every 5 to 10 years. Congress would authorize those statutes for a set period of time and would take seriously its responsibility to revisit those statutes when they expired. And that meant there was always a limit to how out of date or how obsolete those statutes could be. And the agencies played a major role in figuring out how those statutes should be revised. Well, in the environmental context, with maybe one exception, the major statutes have not been updated and revised and reauthorized this century. So part of what Loper Bright is saying is to agencies, look, if the statute isn't giving you the tools that you need to deal with contemporary problems, you've got to go to Congress. You can't make it up yourself. And I think when you apply that same principle to other areas of concern, telecom, immigration, that message really puts a lot more pressure on Congress, because the ability of the executive branch to just freelance and try and repurpose old tools is going to be much more difficult. And I think that Loper Bright didn't do that by itself, but it reinforces that message that we've seen across a range of decisions. Quick word about corner post. I think I'm more sympathetic to that opinion than Stuart is. I think textually it's correct. I think that if you look at statutes across the board, Congress has done a bunch of different things in different statutes. In the Clean Air Act, just to use that as an example, the statute not only has a very strict limit on when challenges to regulations can be filed expressly based on when they were promulgated, it also bars parties from challenging the validity of regulations in the context of enforcement. Why do I highlight that? Because I think what it suggests is that Congress has in different statutes made different choices about whether or not there should be a statute of limitations, whether there should be what we call a statute of repose, where, the clock starts ticking when the agency takes its action and we don't care what your situation is. Congress has made different choices about whether or not regulations can be challenged in the context of enforcement actions, and that the default statute of limitations is written in a way that should allow individuals to challenge actions based on when they were harmed or affected by that agency action, and Congress retains the ability to change that. Another decision that, while I defend it textually, puts pressure on Congress to pay attention to the way different statutes governing different types of subject matter operate. And if some of those statutes need their own statutes of limitations, their own limitations periods, it's Congress's job to do that.
Well, just to note, I certainly agree with that. Both Loper Bright and Corner Post are, besides limitations on the administrative state, clear instructions to Congress that it could fix these problems. The same thing was true going back to West Virginia against EPA. Again, it's very clear that if there's a gap that ought to be remedied, it's in Congress. But of course, this has been an endemic problem for many decades, where to get anything done at all, Congress says, well, this is as much as we can do, and we'll boot the resolution of this to the courts or the agencies or both, or something in between. So textually, there is nothing wrong with Corner Post. Practically, there's everything wrong with it, and so the government isn't working well. I mean, we have an ingenious system of checks and balances. It makes our form of constitutional government unique, since it's based on a written constitution, but it's not working as well as it could. There are lots of elements at fault, including the electorate, but that's the problem that we face. Power abhors a vacuum, and courts have filled it for a long time. And I think what we're seeing is the courts are saying enough. As the Chief Justice pointed out in Loper Bright, there are things within our expertise. We can do those, but in any number of other areas, the courts are telling the political branches, do your job, and they're telling the agencies that you're doing a job that you haven't been delegated to do. We see that there was a mention earlier of the Jarkizi case, which is a good example, again, along with Loper Bright. where the court is limiting the administrative state, and what to me is a well-reasoned case. I've been arguing about this kind of thing for years, so it's self-serving for me to harp on that. But that's a very good example. It was a case decided by the stereotypical 6-3 split, but as to the majority's Seventh Amendment analysis, I think that it's correct, and the agency that ought to be listening to this more than any other agency is not the SEC, which was the party to that case, but the Federal Trade Commission, which is off on its own in a whole bunch of areas. Again, full disclosure, I'm involved in the matter of non-competes, which has been put to rest for at least a while, but particularly the FTC is going to be the subject of the application of jarcossy. Jonathan, any thoughts on that?
Well, and I completely agree with jarcossy, and I was frankly disappointed that the dissent was as broad and aggressive as it was in jarcossy. I mean, here we're talking about when an agency wants to take an enforcement action against an individual or a firm for fraud, right? So something that was actionable at common law, and doing so administratively in a way kind of displacing what would have been the common law remedy. Right? So one reason we have agencies like the SEC with at least some of the authority it has is that just expecting someone to be able to go into court and sue someone for fraud, or even just have a basic, basic criminal law fraud prosecution is too difficult. We want an agency with expertise that can really focus on this sort of thing, can threaten someone with hundreds of thousands of dollars in fines, in this case, $300,000. And that person should be denied a jury trial, forced to submit to an administrative proceeding that does not follow the federal rules of evidence, so that will allow evidence in that would be kept out of a court. And then if they appeal that, the appellate court's going to be bound by the factual findings of that administrative proceeding that the SEC runs. That to me should be troubling to people. Whatever one thinks of the SEC, whatever one thinks of the individual in this case, I mean, I'm willing to accept for the sake of argument that he was a fraudster and was engaged in all sorts of bad conduct. But the jury trial right in the Seventh Amendment, I think, is exceedingly important, and I think the jarcossy case should have been an easier case. What I think is part of what's going on in the dispute there is the question is, well, how broad is the majority's principle going to go? To what extent is it going to apply to other agency adjudications that aren't about things like fraud? And I think the Chief Justice tries to suggest that some older opinions involving OSHA and other agencies aren't implicated by its decision. I'm not sure I'm convinced by the Chief Justice's distinguishing of those older cases. He kind of says, well, we don't have to overrule that, so we're not. But here's a footnote pointing out that lots of people don't like it. So I think that might be the broader issue. But I think that case is one where, from a rule of law standpoint, saying that if the government is going to prosecute you or take an enforcement action against you and can seek up to $725,000 per violation, you should at least have the option of saying, hey, I want a jury trial. Last note on this, it's important to remember that what the court decided is that you have the right to a jury trial. It doesn't mean that every enforcement action has to go to a jury or even has to go to federal court. And for a lot of regulated entities that want certainty, that want quick resolution, that are like, hey, let's work through this, we'll pay a fine, let's get on with our business, they'll still be happy to submit to an administrative proceeding, just like many criminal defendants submit to plea bargains. The question is that, in this sort of context, do you have a right as a defendant that you can invoke? Yes, you can. I think that's a very important rule of law principle.
I have many questions, but wanted to remind the audience that we have another 10 or 15 minutes, so please feel free to drop more questions into the chat. While we've been spending a lot of time talking about the administrative state, I just had maybe this question bleeds into history and political science a bit, but I think it seems to me that reigning in the administrative state is one of the unifying principles on the conservative and libertarian legal right today. And people may forget, or younger folks be surprised to know, that Scalia was a fan of Chevron, right? He had an influential article in the late 80s where he talks about how Chevron is maybe being read too narrowly, but he concludes, but in the long run, Chevron will endure and be given its full scope because it more accurately reflects the reality of government and more adequately serves its needs. Sort of maybe a speculation question, but has there been this evolution on the legal right in the last 20 or 30 years on administrative law and administrative state questions, and what maybe accounts for it? Either of you, if you have.
I think some of it is you see lots of generational changes on the right, right? So if you just look at among academics on the right, a lot more skepticism, say, of qualified immunity than an older generation of conservatives do. A much less of an emphasis on judicial restraint, as opposed to what, judicial engagement, or just focusing on what the text and meaning of the Constitution requires. So generational changes are to be expected. I think that's part of it. I think part of it is that Scalia was responding to lower courts that behave very differently than lower courts do today. The way they interpret statutes was much broader, was much more purposivist, was more aggressive. And so he was more concerned about judges than about bureaucrats. I think today that's shifted some. Courts pay more, both left and right. Courts pay more attention to text. They pay more attention to process than they might have in the 70s. And I think that's part of the shift. I think also Scalia's views of executive power, I think, drove some of his views of Chevron. And it's not clear to me there's as much consensus about executive power as there was 30 years ago.
Well, I think that's certainly so, although there is a vacuum while the court is conscious of it and is withdrawing from some phrase, and I'll talk about a couple of those cases in a second, or a few seconds. I think Scalia was largely right. But I note another thing, though, is if you look at recent presidential administrations, each president, especially a two-term president, gets to appoint a significant percentage of the judiciary. While it may be a lifetime appointment, a significant percentage of those appointed to district courts don't spend their lifetime on those courts. There's a lot of turnover. And so to go back in history to things that led to Chevron, which was inconsistency among the courts and changes within administrations as courts were more sympathetic to not because it's automatically political, but because they just agreed philosophically on the same things on jurisprudential matters, that agencies or that courts rather were shifting their views and taking to themselves the work of agencies. As I mentioned, Chevron itself has undergone evolution over time, to the point where it wasn't necessary for the Supreme Court to rely on it at all. So I think we'll reach a useful position with regard to that over time. That a prior precedent will work well enough, and there will be this. As Justice Kagan said, and she tried to withdraw from the statement at various times, but she was right in saying we're all textualists now, and they are, and you can see that in cases. In a way, the case that I think people will study for a long time is the Fisher case, Fisher against the United States. Which was remarkable. Everybody in the press talks about how the justices line up like ducks in a row, depending upon who appointed them. But in Fisher, you had liberal Justice Jackson joining with the conservative majority, while conservative Justice Barrett joined with the two remaining liberals in dissent. And while it's an important matter, having to do with whether many demonstrators on January 6, 2021 could be prosecuted under the Sarbanes-Oxley Act, which largely refers to matters of paperwork, but also has the word otherwise in it, which was the linchpin of the debate on both sides. It was interesting to see the way the justices lined up and to see how textualism can be debated on both sides. Of course, it was and is in every firearms related or gun or ammunition related case that comes down the pike. But we are all textualists now. Fisher is a good example, whether you like the result in it or not. It's a good example of how text can fairly be debated, and that is the battleground. So I as I say, because of the unusual lineup of justices, I found it to be a particularly interesting case, though I personally wasn't terribly happy with the result.
We're reaching the end of the hour, and we haven't much talked on or touched on the cases that implicate free speech. And because the support of free speech in the First Amendment is in our mission statement, I wanted to get reactions from the two of you. I suppose there's Murthy, Net Choice, NRA. Perhaps I'm missing one or two, but if there's any takeaways from where the court is on free speech issues, and then maybe particularly sort of the modern ones that deal with pressure from the government and private actors.
I would just, I mean, the court's protective of speech. I mean, I think the NRA case shows that quite clearly.
Unanimous, right?
Sorry? Yes, unanimous.
Unanimous?
But the court's also sensitive to not saying more than it feels it can say if the factual record isn't sufficiently developed, if things really need to percolate more in the lower courts, if allegations aren't substantiated, right? So the Murthy case, Justice Barrett writes the opinion saying no standing, I think correctly. I think there's an implicit message there to lower courts and to advocates that, just because you think a majority of the court agrees with you doesn't mean you can be sloppy, right? You still got to bring your A game. You still got to do the work. I think you see that message in a bunch of cases this term. And in the Net Choice cases, again, I think you see a lot of sympathy for the First Amendment concerns, but the court wasn't going to make some broad sweeping judgment given its concern that you have these broad statutes and no real clarity about precisely how broadly they apply. And so wanting the lower courts to do the work.
Yeah, I think that's true. And I mean, the court clearly doesn't want to take a bridge too far. And you see that with regard to firearms. You see it with regard to reproductive rights with respect to mifepristone, which was digged. Atchison Hotels against Lawfer, a standing case where the court is restraining itself and is not going as far as a lot of the political advocates would have it go. That's particularly true, I think, with respect to the Idaho case. A lot of people don't think that's particularly good news. I think one ought to look at it as a restraint on the part of the court. Same thing was true with respect to firearms. And as I say, I think originalism has peaked, and that this selective the courts are proving to be terrible historians, as real historians are pointing out. And the idea of cherry picking history, and I think Justice Barrett is right on the money with her criticism of Justice Thomas, is something to watch. I think we've seen a lineup that has they had a rocky start, but you more often than not see Justice Kavanaugh and Justice Barrett in lockstep on. Oh, excuse me, Justice Kagan, Justice Kavanaugh and Justice Kagan in lockstep on many cases, and I think you'll continue to see that. I think that Justice Kavanaugh will be the heir apparent or the actual heir to the sequence of administrative law experts that had Justice Scalia, then Justice Breyer, and as I say, I think Kavanaugh will be the next in line, and we'll see him taking the lead in administrative law cases, though that wasn't the case in Loper Bright. But I think we'll see it in the future. Loper Bright will spawn other cases. So I think the court is telling us a number of things. In summary, it's putting the brakes on the administrative state. It's telling Congress that if it wants to delegate, it should delegate. It should delegate clearly. It's limiting the executive to things that the executive ought to be doing. It's urging Congress to act. It's defining within limitations the kind of things that we see. To me, most of constitutional law depended upon two concurring opinions. One was Brandeis and Ashwander against TVA, and the other was Justice Jackson in Youngstown Sheet and Tube. I think if you from the standpoint of the judicial role, those two cases tell you everything you need to know, and I think at least those two concurrences tell you everything you need to know. And I see the court going that way. That we're entering a period of somewhat greater judicial restraint. That's the way I see things. This has been a very interesting term. It's going to be a tough act to follow.
Well, Stuart, you anticipated my closing question, which is what kind of court do we have and where's it going? So I appreciate that summation.
Well, another thing to say about it quickly, Greg, is this idea that there's this constant 6-3 is wrong. That you'll see it in a few cases, but it's a 3-3-3 court, and you've got Alito and Thomas who are out there in the wings. You know that no matter what the issue is, the Indians are going to win with Justice Gorsuch, but to be more serious about it, that he is the heir to Justice Scalia with regard to individual rights, and he will be authoring, as he has several times already, individual rights decisions that you would think would be the province of a liberal. Well, they're the province of a libertarian, and you'll see more of that. Further affiant saith not.
Thank you. Professor Adler, any additional thoughts on what kind of court we have and where it's going?
Well, it's a conservative court, but it is, I think, in a lot of areas, a 3-3-3 court. The one thing I think people should think about this court that we saw more this term than I maybe expected, and I think we're going to see more going forward, is these justices were nominated and appointed with a focus on kind of yesterday's issues. But we're rapidly seeing, just as we see this in the political context, we're seeing this legally, that there's a newer set of issues that don't always cross ideological lines in the same way. And just as President Roosevelt's appointees, who were in lockstep on cases about federal power and the New Deal, splintered when the court's attention turned to criminal procedure and democracy and race and the like, we're seeing that the traditional lineups don't necessarily determine where the justices are going to be if the question's not abortion or affirmative action or administrative state at a high level of generality. And we saw some of that. I think that's important. The second thing, I already noted this, just because the court is conservative or center right doesn't mean that advocates for causes or positions that we can code as center right cannot bring their A game on cases like standing, on cases where the court sent things back to the lower courts. We see the court saying you still got to do the work. You still have to have an explanation and a theory of why we're supposed to do a particular thing. You still got to make sure you have standing and have that we have jurisdiction. You can't just assume that we're on that team and you're going to get a win. And I should say that's a good thing.
Yeah. No, thank you both.
And for those out in the audience of this, you see a high degree of agreement between Jonathan and me. As I say, that's long-standing, but it ought to show you that their actual conservatism, as opposed to the MAGA brand, is something decidedly different. We reflect a right of center view with regard to power and government, the responsibility of the electorate, limitations on the role of the judiciary, what we would hope would be greater energy in the legislature. But while conservatism in the jurisprudential sense has been eclipsed to a certain degree, eclipses end, and one hopes. The current political situation, of course, is a muddle, and no predictions as to what will happen there. But actual conservatism in public affairs is alive and well, and I hope that we've conveyed a message that shows that you can think seriously about these issues and define the problems which we face and what ought to be reasonable solutions that in the end will come down to responsible citizenship.
Well, thank you, Stuart. I couldn't agree more. I think this was a very illuminating discussion, certainly much more illuminating than what you get in the popular press, and more illuminating than when you get from many more ideologically blinkered legal outlets. So thank you for this discussion, both of you. I really appreciate your time. I hope it was useful to our audience. I want to just remind everybody again, we are a membership organization. Would love to count you among our number. Would also appreciate any way you can contribute or support our work. You can find links to do that at the societyfortheruleoflaw.org or in the chat here. Our two next events are in person with Yuval Levin of AEI on July 25th and here online on July 31st on academic freedom and the First Amendment on campus. You can follow us on YouTube, Twitter, and LinkedIn, where we will post updates on our programming and content on a regular basis. Thank you all very much, and thank you two gentlemen again, and I hope you all enjoy these hot summer months. Take care.